Case 1. Liliana Carrillo. Reseda, Los Angeles County, California. April 10, 2021. There are cases in the true crime world that investigators describe as clean. Cases where the evidence is abundant, the timeline is clear, and the legal path from crime to conviction is relatively straightforward. And then there are cases like the case of Liliana Carrillo. Cases where every surface-level fact seems almost impossible to reconcile with the woman neighbors, co-workers, and even family members believe they knew. To understand what happened in that Reseda apartment on the morning of April 10, 2021, you have to go back. You have to understand who Liliana Carrillo was, what her life looked like in the months and years leading up to that morning, and what was happening in the custody battle that had become the defining conflict of her final weeks as a free woman. Liliana Carrillo was a young California woman in her late 20s. She was the mother of 3 children: Joanna Denon Carrillo, who was 3 years old, Terry Denon Carrillo, who was 2 years old, and Sierra Denon Carrillo, who was just 5 months old at the time of her death. The children's father was a man named Marcus Denton, and the relationship between Carrillo and Denton had deteriorated significantly by the time 2021 arrived. There were allegations of domestic violence. There were court filings. There was a custody dispute that had become, by all accounts, deeply contentious and emotionally combustible. People who knew Liliana Carrillo in the period leading up to April of 2021 described a woman who appeared to be unraveling. She had expressed fears that her children were being harmed. She had raised concerns with people around her about what she believed was happening to her kids when they were not in her care. Whether those fears were rooted in documented reality or in a psychological state that had moved beyond rational assessment is something that the courts would later spend considerable time examining. But the fears, whatever their origin, were real to her. They consumed her. In the early morning hours of April 10, 2021, inside an apartment in the Reseda neighborhood of Los Angeles County, Liliana Carrillo killed her 3 children: Joanna, 3 years old; Terry, 2 years old; Sierra, just 5 months old. The precise manner in which the children died was established during subsequent legal proceedings. Investigators and medical examiners determined that the children were killed through a combination of drowning and stabbing. The youngest child, Sierra, sustained a stab wound to the chest. All 3 children died in that apartment, in the place that was supposed to be their safe harbor, in the care of the person the entire structure of their small lives revolved around. After the killings, Liliana Carrillo did not remain at the scene. She left the apartment and fled. She drove north, away from Los Angeles, putting miles between herself and what she had done. She did not get far. Law enforcement in Tulare County encountered Carrillo after she was involved in an attempted carjacking. She approached a driver on the road and attempted to take their vehicle. That incident led to her detention and, subsequently, her identification as the suspect in the deaths of her 3 children in Reseda. She was taken into custody without further incident once officers understood who they were dealing with. The discovery at the Reseda apartment was made by the children's father, Marcus Denton, who went to the residence and found his 3 children dead. The grief that swept through that family, through that community, is difficult to put into words. 3 children, the oldest of whom had just learned what the world looked like from a height of 3 years. Children who had experienced nothing, seen nothing, had their entire lives stretching out before them like an open road. Gone. In the days following her arrest, something remarkable and deeply unsettling happened. Liliana Carrillo agreed to give a television interview. She spoke to reporters from a Kern County jail cell, and in that interview she spoke directly about what she had done. She did not deny killing her children. Instead, she explained, in calm, measured, almost eerily composed language, that she had done what she did to protect them. She said she believed her children were being sexually abused. She said she believed that if she left them alive in a world where that abuse could continue, she was failing them as their mother. She said killing them was, in her view, an act of protection, an act of love. The interview was broadcast and viewed by millions of people. The reaction was almost universally one of horror, not merely at the crime itself, but at the calm, the composure, the almost philosophical framing Carrillo applied to 3 small, irreplaceable human lives. Mental health professionals who reviewed Carrillo's behavior noted that the internal logic she described, however disturbing, was consistent with certain patterns of delusional thinking in which a parent becomes convinced that death is preferable to the suffering they believe awaits their children. This did not excuse the crime. Nothing could. But it became the foundation of the legal defense that would follow. Liliana Carrillo was charged with 3 counts of murder in Los Angeles County. The legal proceedings that followed were lengthy and complex. Questions about her mental competency were raised early and resulted in multiple evaluations. In October of 2023, she entered a formal plea of not guilty and not guilty by reason of insanity. Bail was set at $6 million. As of the most recently available verified records, the case was still moving through the California court system, with the insanity defense at its center. The question before the court, and before whatever jury ultimately heard the evidence, was not whether Liliana Carrillo killed her children. She had acknowledged that she did. The question was whether she was legally responsible for those killings under California law. Joanna Denon Carrillo was 3 years old. Terry Denon Carrillo was 2 years old. Sierra Denon Carrillo was 5 months old. Their names are the only answer that matters. If this case moved you, if you believe these children deserve to be remembered, please hit the like button right now, drop a comment below with their names, and subscribe to Crime Case Zone so you never miss another story. Your support keeps this channel going and keeps these stories being told. Case 2. Carrillo, Sacramento County, California. March 17, 2011. There are crimes that, when you first hear the details, the human brain simply resists processing them. Not because the facts are unclear, not because the evidence is ambiguous, but because the act itself exists so far outside the boundaries of comprehensible human behavior that the mind staggers at the threshold and refuses to walk through. The case of Carrillo is one of those cases. On the morning of March 17, 2011, in Sacramento, California, a 6-week-old infant named Mirabel Tallo was placed inside a microwave oven by her mother. The microwave was turned on. The infant remained inside for a period estimated by forensic experts at between 2.5 minutes and 5 minutes. Mirabel Tallo died of severe thermal injuries. She sustained 3rd and 4th degree burns across her entire body. She was 6 weeks old. Carrillo was 29 years old at the time of her daughter's death. She was a Hmong American woman living in Sacramento, and in the immediate aftermath of Mirabel's death, she told investigators a story that bore no resemblance to what the physical evidence would ultimately reveal. She claimed she had been having a seizure. She claimed that during the seizure she had lost consciousness, lost control of her body, and that during this involuntary episode Mirabel had somehow ended up in the microwave. She said she had no memory of placing the infant there. She said she was a victim of her own medical condition. Law enforcement investigators, forensic experts, and medical professionals examined that claim carefully and systematically. What they found did not support it. The physical evidence at the scene was extensively documented. The condition of the microwave, the pattern of injuries on the infant's body, and the reconstruction of events by forensic specialists all pointed to a deliberate act. Medical experts who reviewed the case testified that the placement of a 6-week-old infant inside a microwave oven and the activation of that appliance was not consistent with an involuntary act performed by someone in a seizure state. Carrillo was arrested and charged with murder. The case wound its way through the California court system for several years. The legal proceedings were complex. Defense attorneys pursued the seizure narrative vigorously, presenting medical testimony about Carrillo's history of seizure activity in an attempt to establish reasonable doubt about her conscious intent. The prosecution responded with forensic and medical testimony of their own, systematically dismantling the involuntary act theory point by point. In November of 2015, more than 4 years after Mirabel's death, a Sacramento County jury convicted Carrillo of first-degree murder and assault on a child causing death. The first-degree murder conviction, under California law, requires a finding of deliberation and premeditation. That jury, after hearing all of the evidence, concluded that what Carrillo did to her 6-week-old daughter was not an accident. It was not the product of a medical emergency beyond her control. It was deliberate. Carrillo was sentenced in December of 2015 to 26 years to life in prison. But the legal story did not end there. In 2021, the 3rd District Court of Appeal of California issued a ruling in the case, formally designated People v. Young, case number C080978. that reversed Kai Yang's conviction. The appellate court found that certain expert testimony presented at trial had been improperly admitted. The ruling was based on procedural and evidentiary grounds relating to the standards that govern the admission of expert witness testimony in California criminal proceedings. The reversal did not mean Kai Yang was innocent. The appellate court did not find that the evidence was insufficient to convict her. It found that the specific manner in which certain evidence was presented to the jury did not comply with California evidentiary law. The practical effect was that Kai Yang's conviction was vacated and the case was remanded for further proceedings, meaning, as of the most recently available verified information, the possibility of a retrial remained on the table. The reversal generated significant discussion in legal and true crime circles, as reversals of this kind often do. For many people who had followed the case closely, the ruling was deeply unsettling, not because the legal reasoning was wrong, but because the procedural correction of a trial error meant that the question of Kai Yang's legal accountability remained, at least technically, unresolved. What is not unresolved is the fate of Mirabel Taulo. Mirabel was 6 weeks old. She had been alive for 42 days. She had not yet had the chance to smile her first real smile, to follow a face with her eyes with intent and recognition, to reach for a finger and hold on. She was, in every meaningful sense, just beginning. She did not get to continue. Mirabel Taulo, 6 weeks old, Sacramento, California, March 17, 2011. Her name deserves to be said out loud. Her story deserves to be heard. If you are watching this and you feel the weight of what happened to this child, please leave her name in the comments below, hit the like button, and make sure you are subscribed to Crime Case Zone. These children deserve witnesses. B1. Case 3. Susan Eubanks. San Marcos, San Diego County, California. October 26, 1997. San Marcos, California sits in the northern inland portion of San Diego County, a community of subdivisions and cul-de-sacs, of working families and children riding bikes in the late afternoon light. It is, by almost any measure, a quiet place. The kind of place where neighbors know each other's names and children play in front yards without supervision because the danger always feels like something that happened somewhere else. On the night of October 26, 1997, it happened here. Susan Eubanks was a 32-year-old woman with 4 sons. Their names were Brandon Armstrong, who was 14 years old, Austin Eubanks, who was 7, Brigham Eubanks, who was 6, and Matthew Eubanks, who was 4. The boys ranged in age across a decade of childhood, from early adolescence down to the age when the world is still mostly magic and the concept of a mother doing anything other than loving you is not yet something the mind can even construct as a possibility. By the fall of 1997, Susan Eubanks's personal life was in considerable turmoil. She was involved in a relationship that had become volatile and painful. There were arguments. There were grievances. There was the particular kind of emotional desperation that comes from feeling trapped inside a situation that seems to have no exit. On the evening of October 26, 1997, Eubanks had been drinking. The details of what she consumed, how much, and over what period of time were established during trial proceedings. She had also had a significant argument with her boyfriend, a confrontation that pushed her already fragile emotional state into crisis territory. At some point during that night, while her 4 sons were in the home, while Brandon, Austin, Brigham, and little Matthew were, as best as investigators could determine, either sleeping or in their beds, Susan Eubanks retrieved a handgun and shot each of her sons in the head. 3 of the boys died at the scene. The youngest, 4-year-old Matthew, was transported to Children's Hospital of San Diego. He died the following day. Susan Eubanks survived. After killing her sons, she shot herself in the abdomen. The wound was serious, but not fatal. She was found alive when law enforcement responded to the scene, and she received medical treatment for her self-inflicted injury. When investigators and emergency responders arrived at that San Marcos home and understood the full scope of what had happened inside it, 4 boys, 4 gunshot wounds, 3 bodies at the scene, and 1 child clinging to life, it was described by those first responders in terms that have never entirely left the people who were there. San Diego County law enforcement had seen violent deaths before. They had worked homicides. They had processed scenes that required professional detachment to survive emotionally. This was different. The investigation that followed was thorough and methodical. Susan Eubanks, once she had recovered sufficiently to be interviewed, provided information that helped establish the timeline and sequence of events. The physical evidence at the scene was extensive and unambiguous. There was no question about what had happened in that house or who had done it. The question that the legal proceedings would center on was not one of identity. It was one of culpability, of legal responsibility, of state of mind, of what combination of alcohol and emotional distress and psychological fracture had produced the events of that night. Susan Eubanks was charged with 4 counts of first-degree murder. Her trial in San Diego County Superior Court was one of the most closely watched legal proceedings in the county's recent history. The prosecution presented the evidence of the crime systematically and comprehensively. The defense argued, as defense attorneys in cases of this kind often do, that Eubanks' state of mind on the night of the killings, affected as it was by alcohol consumption, emotional crisis, and what the defense characterized as a form of acute psychological breakdown, should be considered by the jury in assessing her culpability. The jury did not agree. In 1999, Susan Eubanks was convicted on all 4 counts of first-degree murder. Under California law, a conviction for the first-degree murder of multiple victims opens the door to the state's most severe penalty, and in this case the jury returned a recommendation of death. Susan Eubanks was sentenced to death. In the years that followed, the case moved through the California appellate system, as all death penalty cases in California do by statute. The California Supreme Court reviewed the case comprehensively and ultimately upheld the conviction and the death sentence. Then, in October of 2024, a significant development occurred. Susan Eubanks was resentenced. The death sentence was vacated and replaced with a sentence of life in prison without the possibility of parole. The resentencing reflected evolving legal and policy developments in California's ongoing engagement with its death penalty statute, rather than any finding that called the underlying conviction into question. Susan Eubanks remained incarcerated as of the most recently available verified records. Brandon Armstrong was 14 years old. Austin Eubanks was 7 years old. Brigham Eubanks was 6 years old. Matthew Eubanks was 4 years old. 4 boys in one house. One night. One person who was supposed to keep them safe above all others in the world. Their names should not be forgotten. Please take a moment to like this video, leave a comment with the names of these boys, and subscribe to Crime Case Zone. They deserve to be remembered. You can help make sure they are. Case 4. Theresa Knorr. Sacramento, Sacramento County, California. July 16, 1984, June 21, 1985. Most of the cases in this documentary unfolded in a single terrible night. A moment of crisis. A break from reality that lasted hours and then was over. What distinguishes the case of Theresa Knorr from nearly everything else documented in these pages is the element of time. What happened in the Knorr household in Sacramento, California did not happen in a night. It happened over years. It happened slowly, in increments, behind closed doors and drawn curtains, in a house where the children who lived there had no one to turn to and nowhere to go. It happened while neighbors went about their days, while the outside world moved forward in its normal rhythms, while absolutely nothing about the exterior of that family's life announced what was occurring inside it. The full scope of what Theresa Knorr did to her children was not revealed to the world until 1993, nearly a decade after the deaths that resulted from her conduct. The revelation came not from a detective, not from a witness, not from physical evidence uncovered at a crime scene. It came from one of Theresa Knorr's own surviving children, a daughter named Terry, who contacted America's Most Wanted with information about 2 unidentified female victims, Jane Does, who had lain in the California criminal record system for years, connected to no name, no family, no story. They were Theresa Knorr's daughters. Their names were Suzanne and Sheila. To understand the full weight of what happened to them, you have to understand the household in which they grew up. Theresa Knorr was a mother of 6 children. By all documented accounts, she was a controlling, volatile, and deeply disturbed woman whose relationship with her children was characterized not by nurture, but by domination. She appears to have operated according to an internal logic in which her children existed to serve her needs, to validate her, to obey her, to never challenge or question her authority in any way. Children who failed to meet those expectations or who she perceived as threats to her control, were subjected to escalating punishment that moved, over time, from physical abuse to something far darker. Susan Knorr was one of Theresa's daughters. As Susan grew older, she began to push back, in the small, natural ways that adolescents do, ways that in a healthy family would have been managed through conversation and appropriate boundaries. In the Knorr household, resistance was not managed. It was punished. Theresa Knorr shot Susan. The bullet wounded Susan but did not kill her. What followed the shooting was, in some respects, even more horrifying than the act itself. Rather than seeking medical treatment for her injured daughter, which would have meant explaining a gunshot wound to medical professionals, which would have meant the outside world gaining access to what was happening in that house, Theresa Knorr performed what has been described as a makeshift, amateur attempt to address the wound herself, in the home, without medical equipment or training. The wound became infected. Susan suffered. The infection progressed. Eventually, Theresa Knorr made a decision that has no frame of reference in normal human behavior. Rather than allow Susan to receive medical care, she involved two of her sons in the disposal of their sister. In July of 1984, Susan Knorr, who was 17 years old, was taken by her brothers to a remote area in the Squaw Valley region of California. She was bound, doused with accelerant, and set on fire. She died. Her body was found and became one of California's many unidentified Jane Does, a victim with no name attached to her file, no family mourning her publicly, no stories circulating in the press. She waited, unidentified, for nearly a decade. Sheila Sanders, born Sheila Knorr, was another of Theresa's daughters. By the time Sheila reached adulthood and attempted to create some separation from her mother and the family home, she too had become a target of Theresa's pathological need for control and punishment. The documented details of what happened to Sheila in the months leading up to her death in June of 1985 describe a pattern of escalating abuse and deliberate deprivation. Sheila was beaten. She was restrained. She was locked inside a closet. She was denied food. She was denied water. Sheila Sanders died of starvation and dehydration on June 21, 1985. She was 20 years old. Her body, like her sister's, was disposed of. Her remains were found and entered the system as an unidentified Jane Doe. She waited alongside her sister in the files of California law enforcement, unnamed, for nearly the same period. For nearly 9 years, Theresa Knorr lived her life while the remains of her two daughters lay in evidence files and cold case records. She moved. She remarried. She appeared to the outside world as an ordinary woman, unremarkable, undetected. It was the surviving daughter, Terry, who finally brought it all down. In 1993, Terry contacted America's Most Wanted and told investigators what she knew. She named the Jane Does. She identified her sisters. She described what had happened inside that household with enough detail and accuracy to allow investigators to connect the Jane Doe cases to the Knorr family. Theresa Knorr was arrested in 1993. She did not go to trial. In October of 1995, Theresa Knorr pleaded guilty to the murders of both Susan and Sheila. She was convicted and sentenced to 2 consecutive life terms in prison. She was housed at the California Institution for Women in Chino. The legal outcome, guilty, sentenced to life, is clean and final in the way that legal outcomes are. But the case of Theresa Knorr resists the closure that a conviction is supposed to provide, because the question it leaves behind is not a legal one. It is a human one. It is the question of how something like this happens in plain sight, over years, without anyone from the outside world breaking through in time to save 2 young women who deserved saving. Susan Knorr was 17 years old. Sheila Sanders was 20 years old. They waited years to have their names returned to them. They have their names now. Say them. If this story affected you, if you want to help make sure Susan and Sheila are never forgotten, like this video, subscribe to Crime Case Zone, and drop their names in the comments. They waited a long time. Give them a moment. Case 5. Dora Buenrostro. San Jacinto, Riverside County, California. October 25th and 27th, 1994. There is a particular horror embedded in acts of deliberate cruelty toward children that involves calculation. When violence is impulsive, when it erupts from crisis and chaos and emotional disintegration, the human mind, however reluctantly, can locate somewhere within the architecture of psychology a fractured kind of context. Not an excuse, never an excuse, but a framework, an explanation of mechanism, if not of justification. The case of Dora Buenrostro offers no such framework. What the evidence in this case reveals is not impulsive violence. What it reveals is a sequence of deliberate, calculated acts spread across 2 separate days, acts that targeted 3 separate children, that required planning and movement and decision-making, and that were followed by a calculated attempt to place the blame on another person. Dora Buenrostro lived in San Jacinto, in Riverside County. She was a mother of 3 children whose names were Dora, Susana, and Vicente. Dora was 4 years old. Susana was 9 years old. Vicente was 8 years old. By October of 1994, Buenrostro and her husband were estranged, and the marriage had deteriorated into active conflict. What happened next unfolded across 2 days with a precision that investigators and prosecutors found deeply disturbing. On October 25, 1994, Dora Buenrostro placed her 4-year-old daughter Dora in the car and began driving. The stated or implied destination is not entirely clear from the available record. What is clear is what happened during that drive. Buenrostro stabbed her 4-year-old daughter while they were in the car. Dora died. Buenrostro did not call for help. She did not rush to a hospital. She drove to an abandoned post office building in the community of Lakeview and left her daughter's body there. Dora was still strapped in her car seat. A broken knife blade was found embedded in the child's neck. She was left alone in that empty building, in her car seat, dead. Law enforcement discovered Dora's body and began what would become an intensive investigation. But the killing of Dora was only the first act. 2 days later, on October 27, 1994, Dora Buenrostro returned to her home. Her 2 remaining children, Susana, age 9, and Vicente, age 8, were in the living room. The details established by the subsequent investigation indicate that the children were on sofas in the living room when their mother approached them. Buenrostro stabbed both children in the throat. Both Susana and Vicente died. 3 children in 2 days. 3 separate, deliberate acts of violence. After killing Susana and Vicente, Dora Buenrostro went to the police station. She told investigators a story in which her estranged husband was responsible for the deaths. She provided a narrative that cast herself as a grieving, innocent mother and cast her estranged husband as the killer. The investigation dismantled that narrative thoroughly. The physical evidence, the forensic analysis, and the reconstruction of events by investigators pointed unmistakably at Buenrostro. Her husband was cleared. She was arrested. The prosecution of Dora Buenrostro proceeded in Riverside County Superior Court. The evidence against her was substantial. The deliberateness of the acts, spread across 2 days, involving 3 children, followed by a fabricated account designed to redirect suspicion, was presented to the jury as proof not merely of guilt but of the calculated nature of what she had done. Dora Buenrostro was convicted of 3 counts of first-degree murder. On October 2, 1998, she was sentenced to death in Riverside County Superior Court. The death sentence was subsequently reviewed by the California Supreme Court as part of the automatic appellate process that applies to all California death penalty cases. In 2018, the California Supreme Court issued a ruling, formally designated People v. Buenrostro, 6 California 5th 367, that reversed the death sentence based on a finding of error during the penalty phase of the trial. The underlying convictions were affirmed. Buenrostro remained guilty of 3 counts of first-degree murder. The question of her ultimate sentence was remanded for further proceedings. As of the most recently available verified records, the case remained in the California court system. The legal complexity of the subsequent appellate history is worth noting, but should not be allowed to obscure the core of what this case is about. Dora Buenrostro was 4 years old. Susana Buenrostro was 9 years old. Vicente Buenrostro was 8 years old. 3 children. 2 days. 1 person who was supposed to be their safe harbor in the world. They deserved so much better. Their names deserve to be spoken and remembered. If you are watching this and you believe these 3 children should be remembered, hit the like button, subscribe to Crime Case Zone, and leave their names in the comments. They deserve witnesses. Case 6. Pearl Fernandez. Palmdale, Los Angeles County, California. May 22, 2013. In the true crime documentary world, the word case is used so routinely that it can begin to feel clinical, a word that creates professional distance from the human reality at the center of the story. The case of Pearl Fernandez and her son Gabriel resists that clinical framing more stubbornly than almost any other case documented in this program. This is not a case about a single night of violence. It is not a case about a crisis that erupted suddenly and ended quickly. The case of Gabriel Fernandez is a case about 8 months. 8 months during which a child suffered. 8 months during which multiple systems, designed and funded specifically to identify and intervene in exactly this kind of situation, failed. 8 months that ended on May 22, 2013, when 8-year-old Gabriel Fernandez was found unresponsive in the Palmdale, California apartment where he lived with his mother Pearl Fernandez and her boyfriend Isaro Aguirre. Gabriel was transported to Antelope Valley Hospital in full cardiac arrest. Emergency responders documented injuries that reflected sustained and systematic abuse. He never regained consciousness. On May 24, 2013, Gabriel Fernandez was declared brain dead and removed from life support. He was 8 years old. To understand what Gabriel endured in the months before his death, it is necessary to understand the timeline and the documented details, because the scale of what happened to this child in the home that was supposed to protect him is the core of why this case became one of the most extensively reported and legally consequential cases of child abuse in California history. Gabriel Fernandez had been living with his mother Pearl and her boyfriend Isaro Aguirre in Palmdale since approximately the summer of 2012. Before moving in with his mother, Gabriel had been living with his grandparents, by most accounts in a more stable environment. The transition to his mother's apartment marked the beginning of the documented period of abuse. What followed, as established in extensive detail during legal proceedings, was a campaign of abuse that escalated systematically over 8 months. Gabriel was beaten, repeatedly, with hands and with objects. He was burned with cigarettes. He was shot with a BB gun. He was forced to eat cat feces and cat litter. He was confined in a small, enclosed cabinet, bound and gagged, for hours at a time. He was denied adequate food. He had teeth knocked out. He was deprived of basic care and kept in conditions that reflected not parental neglect, but something far more intentional and sustained. Throughout this period, Gabriel went to school. His teachers and school staff documented what they observed: marks, bruises, injuries that he gave varying explanations for, behavior that indicated a child in acute distress. Reports were made to Child Protective Services. Multiple reports. The system that exists specifically to intercept children in Gabriel's situation was activated repeatedly during those 8 months. Those activations did not result in Gabriel being removed from the home before it was too late. The failure of those systems, of the Department of Children and Family Services, of the social workers who were assigned to Gabriel's case, became the subject of a separate and extensive investigation and legal proceeding that unfolded in parallel with the criminal case against Pearl Fernandez and Isaro Aguirre. For Los Angeles County social workers were charged with crimes related to their handling of Gabriel's case. Those charges were ultimately dismissed on appeal, but the systemic failure they represented led to significant reforms in how Los Angeles County's Child Protective Services operated. Pearl Fernandez was charged with first-degree murder with special circumstances of torture. On February 15, 2018, nearly 5 years after Gabriel's death, Pearl Fernandez appeared in Los Angeles County Superior Court and entered a plea of guilty to first-degree murder with the special circumstance of torture. She was sentenced to life in prison without the possibility of parole. Isaro Aguirre was tried separately. He was convicted of first-degree murder with special circumstances and sentenced to death. The documentary made about Gabriel's case, released on Netflix and watched by tens of millions of people around the world, brought his story to a global audience and renewed public attention to the systemic failures that allowed his abuse to continue for 8 months before it killed him. Gabriel Fernandez was 8 years old. He liked Minecraft. He liked superheroes. He was, by all accounts from those who knew him before he moved into that apartment, a happy, bright, sociable child. He suffered for 8 months. He died on May 24, 2013. His name is known. His face is known. His story is known around the world. And it still needs to be told, because the systems that failed him are still operating, and the lesson his case teaches, that reports must be taken seriously, that children who cannot protect themselves depend entirely on the systems and the adults around them, is a lesson that must be repeated as long as children are being harmed. Gabriel Fernandez, 8 years old, Palmdale, California. Remember him. Share his name. Like this video, subscribe to Crime Case Zone, and leave Gabriel's name in the comments. He deserved better. Make sure the world keeps saying so. Case 7. Sonia Hermosillo, Orange County, California. August 22, 2011. Orange County, California presents to the world a face of coastal prosperity and suburban orderliness. It is a place of well-maintained communities and manicured streets, of hospitals and schools, and the infrastructure of modern middle-class American life. Children's Hospital of Orange County, known widely as CHOC, is one of the region's most prominent institutions, a dedicated pediatric medical facility where sick and injured children receive specialized care, where families in crisis come seeking help, where the entire institutional purpose is the protection and healing of young lives. On the morning of August 22, 2011, a woman named Sonia Hermosillo drove to Children's Hospital of Orange County with her 7-month-old son, No Medina Jr. She was not there for a scheduled appointment. She was not there because No was having a medical emergency. What she did when she arrived at that hospital, at a facility whose entire reason for existence was to protect children, stands as one of the most calculated acts of violence against an infant in Orange County criminal history. No Medina Jr. was 7 months old. He had been born with a medical condition that required him to wear a specialized helmet, a device designed to correct the shape of his developing skull. The helmet was not cosmetic. It was therapeutic. It was part of an ongoing course of medical care for a child who had health challenges from the very beginning of his life. On that August morning, Hermosillo drove to CHOC and parked in the hospital's multi-level parking structure. She took No from the car. She removed his medical helmet. Then she carried her infant son to the 4th floor of that parking structure, and she threw him over the railing. No Medina Jr. fell from the 4th floor of the parking structure at Children's Hospital of Orange County. After she did this, Sonia Hermosillo did not call for help. She did not run to her son. She walked back inside the hospital building. She went to a parking payment station. She validated her parking ticket. She walked to her car, and she drove away. No was transported to UC Irvine Medical Center, where physicians fought to save his life. He died 2 days later, on August 24, 2011, from the injuries he sustained in the fall. He was 7 months old. The investigation that followed moved quickly. Surveillance camera footage at the hospital and parking structure documented Hermosillo's presence, her actions, and her departure. Her identity was established. She was located and taken into custody. As the investigation proceeded and the legal proceedings began, Sonia Hermosillo's mental health history became central to the case. Defense attorneys argued that Hermosillo suffered from a significant mental health condition, that her state of mind on the morning of August 22, 2011, was profoundly impaired in ways that affected her legal culpability. The prosecution argued that the deliberate, sequential nature of her actions, driving to the hospital, removing the helmet, locating the railing, returning to validate parking, driving away, was inconsistent with a complete breakdown of rational thought and will. The trial proceeded in Orange County Superior Court. In August of 2021, 10 years after No's death, a jury convicted Sonia Hermosillo of first-degree murder and assault on a child causing death. The following month, in September of 2021, the same jury returned a finding that Hermosillo was legally sane at the time of the crime. In May of 2022, Sonia Hermosillo was sentenced to 25 years to life in prison. The legal proceedings did not end there. In 2024, a California Court of Appeal reviewed the case and issued a ruling that upheld the conviction but determined that the trial court should reconsider whether probation, rather than prison, was an appropriate disposition given Hermosillo's mental health history. This ruling did not overturn the conviction. It did not find that she was innocent or that the verdict was wrong. It identified a specific legal question about sentencing that required re-examination. As of the most recently available verified records, that sentencing review was ongoing. No Medina Jr. was 7 months old. He wore a small therapeutic helmet because his family and his doctors were doing everything they could to give him the best chance at a healthy life. He deserved that chance. No Medina Jr., 7 months old. Orange, California. August 22nd, 2011. Say his name. Leave it in the comments. Hit the like button, subscribe to Crime Case Zone, and help make sure that No's story is one that people continue to hear. He was just beginning. Case 8. LaShaun Harris. San Francisco County, California. October 19th, 2005. San Francisco Bay stretches across the geography of Northern California like a silver mirror, beautiful, vast, and coldly indifferent to the human dramas that unfold on its shores and, on some days, within its waters. Pier 7, on the city's Embarcadero waterfront, is a place of tourists and joggers, of morning light on the water and the sounds of the city beginning its day. On the morning of October 19, 2005, a woman named LaShaun Harris arrived at Pier 7 with her 3 young sons. Their names were Treshaun Harris, who was 6 years old, Theresa Greeley Jr., who was 2 years old, and Joshua Greeley, who was 16 months old. 3 boys, 6 years old, 2 years old, and 16 months old. On a morning in October, at the edge of the San Francisco Bay. What happened next has been documented in court records, in investigative journalism, and in the formal findings of the California Court of Appeal, and it remains, even years later, among the most devastating single events in San Francisco's modern criminal history. LaShaun Harris had a documented and serious history of mental illness. She had been hospitalized multiple times, 6 times in the 2 years preceding October of 2005, for psychiatric conditions, including schizophrenia. She had received diagnoses, she had been prescribed medications, she had been inside the mental health treatment system repeatedly. She had, at various points, been assessed and released. On the morning of October 19, 2005, she took her 3 sons by BART, the Bay Area Rapid Transit System, from their home to the San Francisco waterfront. She walked to Pier 7. At the pier, LaShaun Harris removed the clothing from her sons. Then, one at a time, she took each of her 3 children and threw them into the cold waters of San Francisco Bay. Treshaun, Theresa, Joshua, 6 years old, 2 years old, 16 months old. She later told investigators, and subsequently testified, that she had received a message from God. She believed she was being instructed to sacrifice her children. She believed she was acting on divine direction. The framework of her psychosis, as established by psychiatric evaluation and expert testimony, was one in which the command she believed she had received was as real and as concrete to her as any sensory experience, as real as the pier beneath her feet and the water below. 2 of the children's bodies were never recovered. The body of Theresa Greeley Jr. was eventually found. The investigation was immediate and intensive. LaShaun Harris was located and taken into custody. The case that followed involved not only the criminal prosecution but an extensive examination of the mental health system, of how a woman with such a documented and serious psychiatric history, who had been hospitalized 6 times in 2 years, had not been under sufficient supervision or care to prevent what happened at Pier 7. In 2007, a San Francisco Superior Court jury convicted LaShaun Harris of 3 counts of second-degree murder and 3 counts of assault on a child causing death. The following day, the same jury found that she was not guilty by reason of insanity, meaning that while the jury found she had committed the acts that caused the deaths of her 3 sons, they also found that her mental state at the time of those acts was so profoundly impaired by the psychotic episode she was experiencing that she did not meet the legal standard for criminal responsibility under California law. The practical consequence of the not guilty by reason of insanity finding was that Harris was sentenced to 25 years to life and committed to Napa State Hospital, a maximum security psychiatric facility, rather than to state prison. The California Court of Appeal reviewed and affirmed the case in 2010 in the ruling Designated People v. Harris, case number A116841. The LaShaun Harris case became a landmark in California's ongoing public conversation about the intersection of severe mental illness and the criminal justice system. It raised painful questions that do not have clean answers about the nature of responsibility when the mind is genuinely, profoundly broken, about the duty of the mental health system to intervene when the warning signs are as clear and as documented as they were in this case. About the children who exist inside these situations and who have no voice in determining whether the systems around them are functioning. Trayshawn Harris was 6 years old. Toronto Greeley Jr. was 2 years old. Joshua Greeley was 16 months old. 2 of them were never found. They are still, in some irreducible physical sense, in the Bay. Their names live on in the record of this case, in the court documents, in the reporting that covered their mother's trial, and now here. Say their names. Leave them in the comments below. Hit the like button. Subscribe to Crime Case Zone. These 3 boys deserve to be remembered by everyone who hears their story. Case 9. Socorro Caro. Santa Rosa Valley, Ventura County, California. November 22, 1999. Ventura County sits between Los Angeles and Santa Barbara along California's Pacific coast, a county of agricultural flatlands and coastal foothills, of horse ranches and avocado groves, of communities that carry the quiet self-assurance of places where families have lived for generations. The Santa Rosa Valley is one of those communities, a semi-rural enclave in the eastern part of the county where large lots and custom homes reflect a level of material comfort that speaks of stability and permanence. The Caro family home in the Santa Rosa Valley was, by every external measure, an emblem of that stability. A large, well-maintained property. A successful family with 4 sons and a life that, from the outside, appeared to have everything in order. On the night of November 22, 1999, Thanksgiving weekend, in the year the millennium was about to turn, the Caro family was at home. Socorro Caro was the mother of 4 sons. Xavier Caro Jr., who was 11 years old, Michael Caro, who was 8, Christopher Caro, who was 5, and Gabriel Caro, who was 13 months old. Her husband, Xavier Caro Sr., was present in the home. The marriage had been under significant strain. There had been arguments. There had been discussions about separation, about the future of the relationship, about the kind of marital tensions that many families navigate without arriving anywhere near catastrophe. On the night of November 22nd, Socorro Caro had been drinking. The documented record indicates she had consumed a significant amount of alcohol. There had been a serious argument between Socorro and her husband, an argument about the marriage, about its trajectory, about what was going to happen next. Xavier Caro Sr. left the house. He went to stay elsewhere that night, as had apparently become a pattern during the couple's marital difficulties. He left his wife alone in the house with their 4 sons. In the early morning hours of November 23rd, Socorro Caro entered the bedrooms where her sons slept and shot 3 of them. Xavier Jr., 11 years old. Michael, 8 years old. Christopher, 5 years old. She shot each of them in the head at point-blank range as they lay in their beds. Gabriel, the youngest, 13 months old, was not harmed. After killing her 3 sons, Socorro Caro shot herself in the head. The self-inflicted wound was catastrophic. She survived only after undergoing 2 brain surgeries and an extended period of hospitalization. Her survival was, from a medical standpoint, remarkable. The wound she sustained would have been fatal in the overwhelming majority of cases. When Xavier Caro Sr. returned to the home and discovered what had happened, the response from Ventura County law enforcement was immediate. The investigation documented the scene with the thoroughness and precision that a crime of this magnitude required. The prosecution of Socorro Caro faced a challenge that the case of Susan Eubanks had also presented: how to establish first-degree murder, which requires deliberation and premeditation. In a case where the defendant argued that her state of mind at the time of the killings had been so severely affected by alcohol and emotional crisis that the legal elements of first-degree murder could not be met. The jury was not persuaded by the defense's framing. Socorro Caro was convicted of 3 counts of first-degree murder in Ventura County Superior Court. On April 5, 2002, she was sentenced to death. The California Supreme Court reviewed the case through the automatic appellate process. On June 13, 2019, the California Supreme Court issued its ruling, formally designated People v. Caro, case number S106274, unanimously affirming the death sentence. The court's review was comprehensive and thorough, and its unanimous affirmation of both the conviction and the sentence reflected the strength and completeness of the prosecution's case. As of the most recently available verified records, Socorro Caro remained on California's death row at the Central California Women's Facility in Chowchilla. Xavier Caro Jr. was 11 years old. Michael Caro was 8 years old. Christopher Caro was 5 years old. 3 boys who should have woken up the morning after Thanksgiving weekend and had the rest of their lives ahead of them. 3 boys who never came home again in any way that mattered. Their names deserve to be spoken. Their story deserves to be told. If you are watching this and their names have stayed with you, hit the like button, subscribe to Crime Case Zone, and leave their names below. That is the least they deserve. Case 10. Sandi Dawn Nieves. Saugus, Los Angeles County, California. July 1st, 1998. There is a particular kind of evil that uses the tools of innocence as its weapons. Fire is one of those tools. Fire is what warms a home. Fire is what lights a birthday candle. Fire is what families gather around on cold evenings when the world outside feels distant and the people inside feel safe. Fire, in the architecture of domestic life, is associated with comfort and warmth and the smell of something good cooking in the kitchen. On the night of July 1st, 1998, in the community of Saugus in northern Los Angeles County, a woman named Sandi Dawn Nieves used fire to kill 4 of her children. She then called the fire department to report the blaze. The audacity of that act, the cold, calculating decision to set the fire, wait, and then dial for emergency services as though she were a distressed mother rather than the person responsible for what was happening inside that house, is one of the details that made this case so deeply disturbing to the investigators, prosecutors, jurors, and journalists who encountered it. It was not the act of someone in psychotic crisis. It was not the act of someone who had lost contact with reality. It was the act of someone who had planned, who had calculated, and who believed, at least in the moment, that she could control the outcome. She was wrong about the last part, but the first 2 parts are what the evidence ultimately proved. To understand the night of July 1st, 1998, you have to understand the domestic situation inside the Nieves household in Saugus in the weeks and months leading up to it. Sandi Dawn Nieves was a mother of 5 children. Her oldest was a 14-year-old son. Her 4 daughters were named Nicolette Amber Nieves, who was 12 years old, Rochelle Holly Nieves, who was 11 years old, Crystal Dawn Folden, who was 7 years old, and Jacqueline Marie Folden, who was 5 years old. The household had been under strain. Sandi Nieves had been in a romantic relationship that had come to an end. The dissolution of that relationship had affected her deeply, had produced in her, according to the documented record of the investigation and subsequent legal proceedings, a state of emotional crisis and rage that was building in the days leading up to July 1st. The anger she felt was not directed at her children in any conventional sense. Her children were not the source of her pain, but they became, in the terrible logic of what she decided to do, the instrument through which she expressed it, or through which she intended to punish the person she held responsible for her suffering. The theory advanced by the prosecution and accepted by the jury was that Nieves set the fire as an act of revenge and spite connected to the end of her relationship. The precise psychological calculus that produces that decision, the decision to harm your own children in order to wound someone else, or to express the depth of your own pain, or to exercise a final, annihilating act of control over a situation that felt out of control, is one that defies easy analysis. What the documented evidence established was not the full interior landscape of Sandi Nieves's mind on that night. What it established was what she did. On the evening of July 1st, 1998, the 5 children were in the house. The 4 daughters, Nicolette, Rochelle, Crystal, and Jacqueline, were in the kitchen area, lying on sleeping bags. The 14-year-old son was in the living room. At some point during that evening, Sandi Dawn Nieves poured gasoline. The investigation established that accelerant had been applied in the hallway and in the bedroom areas of the home, in the areas that connected the rooms, in the pathways that the children would have needed to use to escape once the fire started. She ignited it. The fire spread rapidly through those areas of the house. Smoke filled the interior. The 4 daughters, lying on their sleeping bags in the kitchen, inhaled that smoke. They did not escape. Whether they were asleep when the fire started, whether they awakened and were unable to find a path out through the smoke-filled hallway, whether they called out, the record does not answer every question. What the record answers is the final one. Nicolette, Rochelle, Crystal, and Jacqueline Nieves died of smoke inhalation inside that house. Their brother, the 14-year-old, survived. He was found in the living room, covered in soot, alive. Sandi Dawn Nieves called the fire department. When firefighters arrived and gained access to the house, they found the fire already extinguished. It had burned out before consuming the structure entirely. They found the surviving son. They found, in the kitchen, the bodies of the 4 girls. The investigation that followed moved quickly and methodically. Fire investigators examined the scene with the specific expertise that arson cases require, looking at burn patterns, at the distribution of damage, at the physical evidence left behind by accelerants. What they found was not consistent with an accidental fire. The pattern of the burn, the presence of gasoline, the specific areas where the accelerant had been applied, all of it pointed to deliberate ignition. The focus of the investigation turned to Sandi Dawn Nieves. Law enforcement investigators examined her account of the evening. They examined her movements, her statements, her behavior before and after the fire. They examined the state of her relationships, the emotional circumstances that had preceded the night of July 1st, and the physical evidence inside the home. The picture that emerged from that examination was one that the prosecution would present to a jury as proof of premeditated murder. Sandi Dawn Nieves was charged with 4 counts of first-degree murder, 1 count of attempted murder in connection with the surviving son, and arson. The trial proceeded in Los Angeles County Superior Court and attracted significant attention from the regional media. The prosecution's case was built on the physical evidence of deliberate arson, the accelerant patterns, the fire investigator testimony, the burn distribution, combined with evidence about Nieves' state of mind and emotional circumstances in the period leading up to the fire. The defense challenged the arson determination and the inferences the prosecution drew from the physical evidence, arguing that the fire's origin and cause were not as definitively established as the prosecution claimed. The jury was not persuaded by the defense. Sandi Dawn Nieves was convicted on all counts, 4 counts of first-degree murder, 1 count of attempted murder, and arson. The penalty phase of the trial, in which the jury was asked to determine whether she should be sentenced to death or to life in prison without parole, resulted in a death recommendation. She was sentenced to death. The California Supreme Court, as it does in all capital cases in California, conducted an automatic and comprehensive review of the case. The court's review was thorough and extensive. In its ruling, formally designated People v. Nieves, in the California Supreme Court records, the court unanimously affirmed all of the underlying convictions. The jury's findings on each count of murder, on the attempted murder, and on the arson were upheld as legally sound and supported by sufficient evidence. However, the California Supreme Court also found that during the penalty phase of the trial, the portion of the proceedings devoted specifically to determining whether the appropriate sentence was death or life without parole, there had been misconduct on the part of the trial court. The nature of the misconduct related to the conduct of the penalty phase proceedings themselves, rather than to the guilt phase findings. Because the penalty phase error was significant enough to have potentially affected the jury's sentencing determination, the Supreme Court reversed the death sentence while leaving all convictions intact. The practical consequence of that ruling was that Sandi Dawn Nieves was resentenced. The death sentence was vacated. In its place, she received a sentence of life in prison without the possibility of parole, the most severe sentence available to a California court below the death penalty. Sandi Dawn Nieves was housed at the Central California Women's Facility in Chowchilla, where she remained as of the most recently available verified records. The community of Saugus, which in later years would experience its own separate tragedy of a very different kind, absorbed the loss of 4 children in the summer of 1998 in the particular way that communities absorb crimes that feel impossible. There was grief. There was anger. There was the specific, unresolvable bewilderment that comes from learning that someone you might have passed in a grocery store, someone whose children played in the same neighborhoods as your own, had done something so completely outside the frame of what people are supposed to do that the mind simply keeps returning to it, circling it, unable to fully incorporate it. The 4 daughters of Sandi Dawn Nieves were not strangers to struggle. They were children in a complicated household, with a mother whose emotional state had become, in the weeks before their deaths, genuinely dangerous. But they did not know that. Children rarely know when the danger in their lives is coming from the direction they are least equipped to defend against. Nicolette Amber Nieves was 12 years old. She was old enough to have opinions, preferences, friends, dreams about what her life was going to look like. Old enough to have begun figuring out who she was. Rochelle Holly Nieves was 11 years old, 1 year behind her sister. The world was still mostly ahead of her. Crystal Dawn Folden was 7 years old. The age of second grade, of chapter books and learning to multiply. The age when the world is expanding daily and everything is still interesting and new. Jacqueline Marie Folden was 5 years old. Kindergarten age. The age of learning letters and making friends and the extraordinary ordinary magic of being small and alive and just starting out. For girls. For sleeping bags in a kitchen. One night in July, their brother survived. He walked out of that house covered in soot and carrying something that no 14-year-old should ever have to carry. The knowledge of what happened to his sisters and of who was responsible. The case of Sandi Dawn Nieves is, in the end, a case about the weaponization of helplessness. Children are helpless in ways that adults forget or take for granted. Helpless to leave when leaving is necessary. Helpless to protect themselves against adults who should be protecting them. Helpless to know when the environment they have been placed inside has become lethal. The 4 daughters of Sandi Nieves were helpless in every one of those ways on the night of July 1st, 1998. They depended entirely on the adults around them for their survival. The adult most responsible for their survival was the one who poured the gasoline. Nicolette Amber Nieves. Rochelle Holly Nieves. Crystal Dawn Folden. Jacqueline Marie Folden. Saugus, Los Angeles County, California. July 1st, 1998. Their names deserve to be spoken. Their story deserves to be told. If you have watched this entire documentary and these 4 girls are the ones whose names you want to carry with you, then carry them. Say them out loud. Write them in the comments below. Hit the like button. Subscribe to Crime Case Zone. Share this video with someone who needs to hear what happened in that house in Saugus on a July night in 1998. These 4 girls were here. They mattered. Make sure the world knows it. Conclusion. You have just heard 10 documented, legally verified, and court-adjudicated cases from the state of California. Cases that span 5 decades of criminal history, from the 1980s to 2021, from Sacramento to San Diego, from San Francisco to Saugus to Orange County. 29 children. 29 young lives, some of them barely begun, some of them stretching into adolescence, who were failed in the most fundamental and irreversible way by the person the architecture of their entire world was built around. There is an instinct, when confronting cases like these, to reach for explanation. To find the psychological framework, the documented hardship, the situational circumstances that make the incomprehensible slightly less so. And in some of these cases, the documented record does include serious mental health conditions that the courts and the legal system were required to examine carefully and directly. But explanation is not excuse. Context is not absolution. And no framework, however carefully constructed, can fill the space that these children left behind. What this documentary has tried to do, and what Crime Case Zone is committed to doing in every case it covers, is to tell these stories completely, with accuracy, with respect for the legal record, with journalistic standards that reflect the gravity of what happened, and above all, with the consistent insistence that the victims in these stories are not footnotes or supporting characters in someone else's narrative. They are the story. They have always been the story. Joanna Denning Carrillo, Terry Denning Carrillo, Sierra Denning Carrillo, Mirabelle Taulo, Brandon Armstrong, Austin Eubanks, Brigham Eubanks, Matthew Eubanks, Suzanne Knorr, Sheila Sanders, Deidre Buenrostro, Susanna Buenrostro, Vicente Buenrostro, Gabriel Fernandez, Noe Medina Jr., Trayshawn Harris, Taronta Greeley Jr. Joshua Greeley, Xavier Caro Jr. Michael Caro, Christopher Caro, Nicolette Amber Nieves, Rochelle Holly Nieves, Crystal Dawn Folden, Jacqueline Marie Folden. 29 names, 29 lives. Every single one of them deserving of a future and a story and a world that remembered them. These cases remind us why child protection systems matter. They remind us why early intervention matters. They remind us why paying attention to the children around us, in our neighborhoods, in our schools, in our communities, is not optional. It is a responsibility that belongs to all of us. If even one person watching this documentary learns to recognize the warning signs of a child in need, if even one person makes a phone call or raises a concern that puts a child in a safer situation, then these 29 names will have done something meaningful beyond the boundaries of their own short lives. That is the purpose of this channel. That is the commitment of Crime Case Zone. We tell these stories not to sensationalize, not to shock. We tell them because the truth, documented and presented with care and accuracy, is the most powerful tool we have for understanding what goes wrong and what we as a society can do better. These 29 children deserve better. Future children deserve better. And together, through awareness, through accountability, and through the refusal to look away, we can work toward a world where fewer of these stories have to be told. Say their names. Remember their faces. Share their stories with someone who needs to hear them. And if this documentary was meaningful to you today, please hit the like button right now. Please subscribe to Crime Case Zone so you never miss another episode. Please share this video so that these 29 names reach as many people as possible. And please leave their names in the comments below, because every name written in that comment section is one more corner of the world where these children are known, remembered, and honored. They were here. They mattered. They always will. This is Crime Case Zone. Stay informed. Stay compassionate. Stay with us. We will see you in the next one.